Hi, I'm Joel Hamner with the law firm of McCutcheon Hamner. We've been talking about Social Security disability and Social Security supplemental income. Now what I want to do is kind of wrap up what we're doing in filing for Social Security disability income and what you can expect. So we've talked about the initial filing the appeal, we're getting ready to go to a hearing before the administrative law judge, what the administrative law judge is going to look at. So this is really where the administrative law judge is going to make their decision and what they're going to look at. Number one, they're going to talk about they're going to look at your age. We've talked about that. The presumption at various ages, okay? Once again, because of that ability to be retrained for work. The second thing they're going to look at is your job history, okay? What have you learned in your past? You know, are you a block mason? Are you a computer programmer? Are you a store manager? Are you a medical assistant? Have you learned things in your past that create transferable job skills? The next thing they're going to look at is your disability and your physical limitations themselves. You know, what precludes you from working? I've represented folks who have had Crohn's disease. I've represented folks who have cancer. I've represented folks who are in renal failure. I've represented folks who have just a vast number of problems that preclude them from working. There doesn't have to be just, I've had back surgery 5 times, or I've lost a leg or a limb, although those certainly are issues and we represent those too. But there's this feeling out there that, you know, it's not just physical injury or physical disability. It can be due to an illness that precludes you from working. So that judge is going to take all those into consideration in reaching what we call his final decision. Now, it's very important that those all be presented in a concise manner by your attorney. One thing to keep in mind, and this has changed recently with regards to the Social Security Administration, it used to be that we could submit medical records and evidence post-hearing. That is, some judges would leave the hearing open for 20 days for us to submit additional evidence if we had it. They've stopped that now for the most part. Now, it is judicial discretion, and they can do it. But for the most part, the law is now that all the evidence of disability must be presented or be filed 7 days before the hearing. So it is extremely important that whoever your attorney is and whoever they're working with, that you understand and that attorney understand that 7 days before your hearing before the administrative law judge, he better have that record complete. Now, one thing that's going to happen, you're going to go into the hearing, the attorney's going to be there with you, and I'm going to be sitting there beside you, and you're going to hear us talk about the ERE. And what that is that is the electronic file that we have created for you. Now, under the federal government, we don't do hard files anymore, paper files. Everything is submitted electronically. And what we do as your attorney, we go in and we review your electronic file, and we make sure that every document has been filed to support your case. And that is tremendously important. The other thing I do, and I've done this for years, I meet with every individual claimant a day or two before their hearing, because I want to spend an afternoon with you working through your testimony, because ultimately the judge is going to make his decision based upon your credibility. He wants to visualize you. He needs to hear what you have to say. Sure, he's going to have medical evidence before him. Sure, he's going to have all these records before him. But I've always heard judges say they decide cases on the credibility of the claimant, and that's you. So for my clients, I'm going to sit down with you, and I'm going to work with you, and I'm going to go through your testimony. I'm going to give you testimony as to what you should expect. I'm going to go through most of the questions a judge is going to ask you. I'm going to cross-examine you. I'm going to have you prepared for your hearing as much as I possibly can. And if your attorney is not doing that with you, well, he's not really doing all he should do to ensure that you have the most chance of qualifying for your benefits. So we'll go through, we'll have our hearing. Most hearings last about 45 minutes to an hour. We'll present your case. Sometimes we have witnesses, sometimes we don't. And then the case is over. Most judges take the case under advisement. What that means is this. They're going to review your testimony. They're going to review the testimony of any witness we present. They're going to review the testimony of the vocational evaluator. They're going to review the medical records and medical evidence we presented. And then they're going to make a decision. Typically, most decisions are provided by our administrative law judges within a period of 3 to 4 months. And from then, they let us know whether you've qualified for benefits or whether the benefits have been denied.